Yeah, so we've discussed various aspects of directors, and we did note that directors are very important because they are responsible for the day-to-day decision making in the company on behalf of shareholders and all that. And we indicated that there is this problem of what we call the agency problem, right? Agency problem in corporate governance. What does that mean? That is to say that directors, what is of interest to directors, not necessarily the same as things which are of interest to shareholders. Shareholders would like to maximize their wealth, would like more profits. Directors would like to get more emoluments, that is more remuneration. And for that matter, you have that kind of a disconnect between what directors are interested in and what shareholders are also interested in. So directors on their own may, for example, want to manage the company in such a way which will advance their interests. And as I've told you, their interest is not necessarily coterminous with the interest of that of shareholders. In other words, their interest as directors is not aligned with the interests of shareholders. That is to say that while shareholders are thinking of how to increase profits so that more dividends will be declared, directors are thinking of something different. What are they thinking about? They are thinking of how they should be giving more remuneration, right? More allowance or more emolument, as it were. And that is why we see that kind of divergence between the interests of directors and then that of the shareholder. And for that matter, there is that challenge on the part of shareholders. How can we monitor or how can we police directors so that directors do not actually run the company in a way which would advance only their interests to the detriment of that of other shareholders. Now, in corporate law theory, we call that agency cost. Agency cost, that is the cost or the burden of having to monitor directors so that they don't act opportunistically. Opportunistically in the sense that they don't exploit their privileged position as directors to the detriment of that of shareholders and, of course, other stakeholders as well. So within that context, we discuss the what we call the stringent requirements which directors must actually meet in terms of qualification before they are appointed. Because you want to make sure that you're putting like the right guy there, because you cannot police what the director, the kind of decisions that they're making 24/7, isn't it? So you want to make sure that you put the right guy there that you can trust, even when you go to sleep, that he will do the right thing for the good of the company and for your good as a shareholder, as it were. So last time, we were supposed to have discussed directors, duties of directors, and you started that with the Dr. Thaddeus, and duties of directors within also the context of the tutorial questions. You know, the tutorial questions that he gives you meant to challenge your thinking so that you look at the law and use that to organize also how you think as well. So the duties, as you notice, we have the two sets of duties, the statutory duties of directors, and also, if you like, the common law and equitable duties, as it were. And why do we say that? Now, if you look at Act 992, as you very well know, the duties of directors start from section 190. It starts from section 190, even right up to, you wanted to drag it further, right up to 210. And we also have some matters which apply to both directors and other officers like secretary. So then you continue with the 213 to 217. But I would like you to pay, let's jump to section 217, then I'll come back and make the point I want to make. If you go to section 217, any of the class reader or any volunteer to help at 217, is a person, anybody who wants to help? So that I will leave you and make you a co-host. Yeah, who wants to read for us? Okay, Sally. So Sally, let me make Sally a co-host. I think I didn't have a co-host. So. I did not have co-hosts here. Only in the, I don't know. Let me see if it worked that way. Oh, so they don't allow go. Okay, then I can unmute him. Sally.
Sally's reading.
Oh, Sally's speaking. Oh, right.
No, please. Hi.
Hello.
Yeah. So 217. Let's go. Yeah, Sally. Whoever, anybody.
General saving of existing law relating to officers. 217. The rights, duties, and liabilities of officers and agents of companies shall continue to be governed by the rules of a common law, and equity relating to principal and agent, master and servant, except insofar as those rules are not inconsistent with the express provisions of this Act.
Okay, good. Now, section 217 actually reinforces the observation that we made earlier, that in talking about duties of directors under Ghana Companies Law, we could broadly say that there are two categories of duties. We have the statutory duties, and then we have what we call the common law, of course, including equitable duties as well. And the 217 is the basis of the common law or equitable duties of directors. And that is why 217 says that all the things we know under common law and equity regarding agents, so agents and principal, or regarding master and servant, they are mutatis mutandis, that is with necessary modification, applicable to company directors. So therefore, all the things that you are learning in commercial law, okay, concerning in agency law, concerning principal and agents, they are considered as being applicable to directors. Insofar as directors are also reckoned as being fiduciary, right? So all the things that you are learning over there, they are also applicable to them. So let us keep that in mind. And In terms of like the statutory obligations, of course, we have to start from section 190, and where we are told that a director stands in a fiduciary position. So director standing in fiduciary position, we've explained it before, simply means that the position that a director occupies is a position of trust and confidence, right? Position of trust and confidence. And for that matter, the director is expected to exhibit utmost good faith towards the company in transaction with and on behalf of the company. If the director is doing anything with the company or for on behalf of the company, the director is expected to actually be honest, and be transparent as far as the company is concerned. So let us keep that in mind. And that is a section 191 that to start with, directors stand in fiduciary relationship. So as soon as we hear that, then all the things you know in law which apply to fiduciary relationship are applicable to directors. I mean, that is a very basic thing that we should keep in mind, that as soon as you get to know that directors actually stand in fiduciary position, then all the things that we know concerning fiduciary position are applicable to directors. And of course, what section 191 has said has also been retreated already, even by case law. So section 191, in a sense, is just a reenactment of what is known in judicial decision. So if you look at the case of Regal Hastings Limited against Gulliver, let me put it here. Regal Hastings Limited against Gulliver. (1942). 1942. Okay. HL1. Yeah, so in why did it go to only one person? To Vasco. It's meant for everyone. Yeah, okay. Yeah, so in Regal Hastings Limited against Gulliver, for example, Lord Russell will make the point, quote, "The rule of equity which insists on those who by use of a fiduciary position make a profit, being liable to account for the profit, in no way depends on fraud or absence of bona fides, or upon such questions or consideration as whether the profit will or should otherwise have gone to the plaintiff, or whether the profiteer was under duty to obtain the source of the profit for the plaintiff, or whether he took a risk or acted as he did for the benefit of the plaintiff, or whether the plaintiff has in fact been damaged or benefited by his action. The liability arises from the mere fact of a profit having, in the stated circumstances, been made. The profiteer, however honest and well-intentioned, cannot escape the risk of being called to account." So what Lord Russell of Kilowin is trying to underscore in Riga Hasten Limited against Gulliver is that because a director is a fiduciary, he stands in a unique position. He cannot engage in any transaction and expect that he will never have to render an account regarding what he did on behalf of the company or what he did with the company. So that is the point the court is trying to make. But if you look at the 190 subsection 1, it talks about the duty to act with utmost what? Good faith. Duty to act with utmost good faith. What does that actually entail? What does it mean to say that you're supposed to act with utmost good faith in a transaction on behalf of the company? I mean, that's what we'll be using various words to illustrate. That is to say that you are supposed to always act with open mind without any intention to overreach the company, that is exploit the company. You are going to be very honest regarding every aspect of the transaction. So let us keep that in mind. And that is why in the old case of Ernest Smith and Fawcett Limited, Ernest Smith, Smith and Fawcett Limited, (942) Chancellery 304. In Ernest Smith and Fawcett Limited, the issue share capital of a company was held 50% each by 82 directors. So each director had 50% of the shares of the company. One director died, and his executor, that is a person appointed to be in charge of his estate, applied to have his shares registered in his name. The remaining director refused, but offered to register half the shares and to buy the remainder at a fixed price. So don't forget, two directors, one is going to live with one, and then the other one is trying to behave in a very suspicious way regarding the interest of the other director, who was also like a shareholder. The executor, that is a person in charge of the director who has died estate, sought rectification of the register of members, alleging breach of fiduciary duty in refusing to register the shares of the deceased director. And it was alleged that the surviving director was motivated by a collateral purpose, namely the desire to acquire half of the deceased director's shares at an undervalue, that is at a cheaper price than the shares will have been actually sold. The articles of the company, that is the constitution of the company, provided that directors may at any time in their absolute and non-controlled discretion refuse to register transfer of shares. So the Constitution made this provision. So despite such a wide power, the court held that the director was still subject to fiduciary duties, which required him to exercise his powers bona fide in the interest of the company. Bona fide simply means that in good faith, in utmost good faith, in the interest of the company. And the court explained that this meant bona fide in what the director considered and not what a court may consider is in the interest of the company and not for any collateral purpose. In other words, the court was saying that the good faith which the director is supposed to show is in what the director considered to be in the interest of the company and not what of course the court will consider to be the interest of the company, or not what the director will consider to be in the interest, like for any other collateral purpose. Collateral purpose means that things not directly for the benefit of the company, but for some other ulterior means. So based upon the evidence before the court was not satisfied that the surviving director was not acting in what he considered to be the interest of the company. And for that matter, the application to rectify the register brought by the executor of the deceased director in shareholder failed. But in that case, Lord Green, who was master of the rules at the time, when we say master of the rules, it refers to the president of English Court of Appeal, master of the rules. Yeah, so Lord Green, master of the rules at the time, made a certain dicta, which illuminates our understanding of what it means to say that a director has a duty to act with utmost good faith. And I quote, the principles to be applied in cases where the articles of a company confer a discretion on directors with regard to the acceptance of transfer of shares are, for present purposes, free from doubt. They must exercise their discretion bona fide in what they consider, not what a court may consider is in the interest, not what the court may consider is in the interest of the company and not for any collateral purpose. It must have regard to those considerations and for those considerations only, which the articles on their true construction permit them to take into consideration. And in construing the relevant provisions in the articles, it is to be borne in mind that some of the normal rights of a shareholder is a right to deal freely with his property and to transfer it to whomsoever he pleases. The question, therefore, simply is whether on the true construction of the particular article, the directors are limited by anything except their bona fide view as to the interest of the company. In the present case, the article is drafted in wildest possible terms, and I decline to write into that clear language any limitation other than a limitation which is implicit by law, that a fiduciary power of this kind must be exercised bona fide in the interest of the company. So the court, the judge will go on and just trying to make the point that yes, if you look at the constitution of the company, they have a broad discretion as to whether to agree to propose transfer of shares or not. And insofar as there is no evidence that the director fiduciary has actually not used that power in any way, which will show that he is trying to be dishonest or is trying to do anything which is not considered to be in the interest of the company, the court will not actually interfere. So I think that the takeaway for us is that the point about section 191 is that a director being a fiduciary must act in utmost good faith. I'm told that this meeting will end in 10 minutes because we are raising a basic account. So when it ends, we'll use the same link to come back, right? Now, another duty of directors, which you have discussed, is what we find in subsection 2, section 190, subsection 2. That is a duty to act in the best interest of the company. So will the reader take it for us?
(192). A director shall always act in what the director believes is the best interest of the company as a whole, so as to preserve the assets, further the business, and promote the purposes for which the company was formed, in the manner that a faithful, diligent, careful, and ordinarily skillful director would act in the circumstances, and in doing so shall have the regard to A, the likely consequence of any decision in the long term, B, the impact of the operations of the company on the community and the environment, and C, the desirability of the company, maintaining a reputation for high standards of business conduct.
Okay. Now, section 190, subsection 2 is quite a major development as far as duties of directors are concerned. So first of all, we pick from there that the director is supposed to act in the best interest of the company, okay? And acting in the best interest of the company, it has to be within certain parameters. In other words, how can we know that the director has acted in the best interest of the company? And that is why, among other things, we've also been given certain parameters. So if we look at the subsection 2, we have A, B, C. So all the parameters are there, which is supposed to help us to determine whether any particular course of action or decision which a director undertook, whether it can be considered as being in the best interest of the company. Then the question may also arise, whose duty it is to determine the best interest? Do we use the objective test or the subjective test? Now, it is both objective and subjective, because if you look at the provision that the director shall always act in what the director believes is in the interest of the company as a whole. So it is subjective in the sense that the courts will have to defer to the business judgment of the director when it comes to decisions which are considered to be prudent in terms of business. The court is not going to second guess. The court is not going to second guess what a director will say or what the director will do. And that point has been well made in the case law long before even our repeal at 179 and also. So if you look at the old case of Howard Smith Limited against Ampol Petroleum Limited, and every student of company law who has learned directors is supposed to know what we mean by this. Okay, Louis Osei asked a question. What does it mean to have no collateral purpose? Okay, so the collateral purpose here, we are referring to instead of using the power to do what the power has been conferred, right? You're a director, be given power to do certain things. Instead of using it for what the reason for which the power has been conferred, you want to use it in order to achieve a certain personal objective or objective which is not related to the purpose for giving you that power. So that is what we mean by the collateral purpose, Lloyd, sorry. So I mentioned the case of Howard Smith to illustrate the point that when it comes to what is considered to be the best interests of the company, there's an aspect of business judgment. And as far as business judgment is concerned, the courts will have to give in or will have to defer to what the directors in their discretion have actually decided, rather than trying to second guess, because the courts are no better placed to make business judgment than directors. And that is what Howard Smith Ampol, and every law student knows this case. Howard Smith Ampol. Limited, 1974, AC 821. Yeah, so in Howard Smith Limited against Ampol Petroleum Limited, the business judgment rule, which I have explained, has mean that the courts will actually not interfere with the business discretion exercised by directors, was explained, and I quote, in order to assist him in deciding upon the alternative motivation contended for, the judge considered first, at some length, the objective question whether Millers was in fact in need of capital. This approach was criticized before their lordship. It was argued that what mattered was not the actual financial condition of Millers, but what the majority directors bona fide considered that condition to be. Their lordship accept that such a matter as the raising of finance is one of management within the responsibility of the directors. They accept that it would be wrong for the court to substitute its opinion. And this is the crux of the matter, ladies and gentlemen. They accept that it would be wrong for the court to substitute its opinion for that of the management, or indeed to question the correctness of the management's decision on such a question, if bona fide arrive at. So this is what they call the statement of the business judgment rule, that the courts, when it comes to whether what the directors have done, whether it is prudent in business and sense calibration and all that, the court are saying that they cannot substitute their opinion for that of management. They cannot second guess management, or they cannot question correctness of management's decision, so long as they've arrived at that decision in good faith. I'm told that we have less than 1 minute and then we are going to go off. So it will end soon in a few seconds, and we'll use the same link to come back.